Dear learners, welcome back to your educational channel Learn and Educate, where we were studying a few basics about the goods and service tax. Continuing that series, now section 2, clause 99, revisional authority. The revisional authority means an authority who is appointed or authorized for the revision of decision or order as referred to in section 108 of Central Goods and Service Tax Act. The authority which has been appointed for the purpose of revision of decisions or order which has been mentioned in section 108. Chapter 18 relates to appeals and revision. Under that, when section 108 specifically relates mention the provisions relating to the powers of revisional authority subject to the provisions of section 121. It mentions about the subject to the provisions of section 121 and in the rules made thereunder. The revision authority, it has the power on its own motion or upon information which has been received by them on the request from the Commissioner of State Tax or Commissioner of Union Territory Tax, call for and examine the records of any proceedings, and if he considers that decisions or order which has been passed under the Central Goods and Service Tax Act or under the State Goods and Service Tax Act, or the decision passed or order passed under the Union Territory Goods and Service Tax Act by any officer who is subordinate to him has made is erroneous insofar as it prejudicial to the interest of the revenue and is illegal or improper, or has taken into account the certain material facts whether available at the time of issuance of that order or not, then any consequences of an observation made by the CNAG, if it stay the operation of such decisions or order, then as it deemed fit shall pass after hearing and after making such further inquiry, the revisional authority shall pass an order as he thinks fits, proper and just, including enhancing or modifying or ending the decisions or order passed. Thereafter, the decision specified, the order has already made, taken for the revision under this section, and the order has been passed in exercise of the powers under subsection 1. Therefore, when at the issuance of an order under the subsection 1 is stayed by an order of the Court of Appellate Tribunal, the period of stay shall exclude the computing the period of limitations. Therefore, now as per section 121, which relates to non-appealable decisions and orders, which states that anything which is contrary to the provisions of Central Goods and Service Tax Act, no appeal shall lie against any decision taken or order passed by any officer of the central tax if the decision taken or order passed relates to any one or more of the following matters, which are any order of the commissioner or other authority which is empowered to direct the transfer of proceedings from one officer to the another officer, an order pertaining to seizure or retention of the books of accounts, registered or other documents, an order sanctioning the prosecution under this act, or any order which has been passed under section 18. Therefore, as per section 108, as referred to in section 108, the appellate, the revision, the order passed by any officer or any subordinate to the revisional authority shall then the power of the revisional authority to modify or revise the decision or the order as referred as passed on by any officer which is subordinate to him.